Welcome back to this third segment of this public law session on EU law. Again, I will remind you to make sure that you're contextualizing this in respect of public law. The point that was made before we took the short break, of course, was that when you look at the principles of direct effect and direct applicability, they are very important in the context of EU law. Now, their importance cannot be underestimated. And what I'm going to do now is to let you imagine an example which I will use. And that example is this. If you imagine that fictitiously, please, there's no such thing, fictitiously, let's assume that the EU wants to regulate nut products in member states. So if you are a baker who makes products which contains nuts, then let's assume that that needs to be regulated. Well, let's assume that the way that it is to be implemented is by a regulation. So let's call it the nut allergy regulation. Well, if it is a regulation, it would be directly applicable, and it would mean that if I'm a baker in a member state, and for example, let's say the nut allergy regulation said any baker who bakes products which contains nuts must carry a written warning. Well, if it is that I am just a private company doing baking, then any individual who buy my products will be able to bring an action against me based on that regulation. Now let's assume that the EU decided that, all right, what we will do is, based on this fictitious nut allergy phenomenon that we want to control, we will do it by way of a directive. So let's say they issue it as the nut allergy directive. Well, the first thing that would be in there would be a date by which member states need to implement. So let's say that date is January 1st, 2015. Well, if it is that I am a baker, a private company, the thing is that because it is a directive, it is not directly applicable like a regulation, but it may have direct effect to the extent that if the UK, which is my member state, has not implemented by January 1st, 2015, and then you buy a product from me which has nuts, but it did not, for example, have any warning, and let's say you buy this in February 2015, again, you still couldn't bring an action against me because directives do not have horizontal direct effect. However, direct effect means being able to bring an action in front of your national court. You could bring an action against your national court, but as against the state, the UK. And how you would do that, of course, is the way it's done in the UK is you bring an action for a breach of statutory duty in that they have not implemented the directive, the date for implementation has passed, and as such, you would be able to bring an action against the state for non-implementation of the directive, but it would not be against me personally. Now, the other way that vertical direct effect operates, of course, is let's say the bakery that I operate is a state bakery. Well, you would not necessarily, it would still be vertical direct effect, but you would not necessarily bring the action against me for non-implementation of a directive. You could, as an individual, bring the action against me on the basis of a breach of the directive, because as a state bakery, I would not be able to hide behind the fact that, well, the government hasn't implemented it, but it would still be considered along the lines of vertical direct effect. Now, direct effect is not explicitly mentioned in any of the EU treaties. The principle of direct effect was first established in relation to provisions of the treaties of the EU, and it was certainly established in the case of Van Genenloos and Netherlands. And we see that direct effect has subsequently been loosened in its application to treaty articles, and the ECJ has expanded the principle, holding, of course, that it is capable of applying to virtually all of the possible forms of EU legislation, the most important of which are regulations and certainly, in certain circumstances, directives. Now, the direct effect principle, when the ECJ or the CJEU first articulated it in the doctrine, articulated doctrine in the case of Van Gen and Loos, the European Court of Justice laid down the criteria, and it's commonly referred to as the Van Gen criteria for establishing direct effect. And it goes like this. Now, a treaty article, or indeed a regulation, or indeed a directive, if applicable, if there is a provision on which you're seeking to rely in respect of direct effect, the Van Gen requirement says that the provision must meet 3 criteria. It must be 1, sufficiently clear and precisely stated. It must be unconditional and not dependent on implementation, as it were, from the member state. And third, it must confer a specific right on the citizen in order to base his or her claim. Now, the treaties are not such that they are capable of having direct effect. You cannot say, I'm relying on the treaty before my national court. So the treaty in its complete form does not have direct effect. But a treaty article may have direct effect. Now, if the Van Gen criteria are satisfied, then the right or the rights in question can be enforced before national courts. Of course, whether or not any particular measure satisfies the criteria is a matter of EU law, and it is, of course, the Court of Justice of the EU which decides that. Now, we see that there are different varieties of direct effect, and in Van Gen, it was decided that a citizen was able to enforce a right granted by European Community legislation against the state, and the question of whether rights could be enforced against another citizen was not addressed. Now, in Defrain and Sabina, the European Court of Justice decided that there were 2 varieties of direct effect: vertical direct effect and horizontal direct effect. They drew the distinction, and it is, of course, what I've discussed before, and I'm certainly not going to labor the point. What I will raise, though, is that when you're looking at the state, one of the things that becomes important is whether or not something or a body is considered an emanation of the state. And this is defined in Foster and British Gas. Now, emanation of the state is a term which is used in European law to describe any body which provides a public service under the control of the government, or to put it another way, they provide a service where in their absence the government would have to provide it. Now, the term was defined by the ECJ then as any body, as it were, which would carry out these functions. So if you were an emanation of the state, then of course vertical direct effect would also apply. And again, as I said, it is not going to be a situation where you as a state body are able to hide behind this, well, it's the government and they haven't implemented. So the action can directly be brought as against that state agency or body, but the way that it is considered is that it is still vertical direct effect. Now, the idea is that you must be able to grasp and explain these principles, because again, when you look at the supremacy of EC law, when you look at the doctrines of direct effect and indirect effect, all of these have come out, or rather they've been fleshed out by the Court of Justice of the EU. They've been given flesh onto their bones. Now, you need to also be aware, as I say, of the various pieces of legislation which come out and how direct effect operate in regards of those. Now, when you look at the leading case law for direct effect of directives, we see the Van Dyne case, which of course established vertical direct effect. There's also Marshall and Southampton, which established that there is no horizontal direct effect of directives. Again, the idea is that a directive, based on the fact that it has not been implemented, your action will only be as against the state. It will not be such that you can bring it as against an individual. Now, there are other ways of construing legislation, and one of them, of course, is indirect effect as well. So direct effect, as I say, you can rely on it in front of your national courts. If you're looking at directives, I would certainly also refer you to the case of Frankovic and Italy, because that certainly stands for the proposition that it is only if the date of implementation has passed that you will certainly have any kind of rights. Now, if it is that the date for implementation has not passed, then unfortunately, as much as you may have suffered as a result of something which arguably the EU was looking to protect, you will, of course, not be able to substantiate any sort of action, because the idea is that when you look at directives, they don't have that teeth and bite like, for example, regulations. Now, even when you're bringing your action, be it that it is, for example, a regulation is a non-implementation, whatever you suffer, there must operate a causal link between the loss you've suffered and the failure to implement. Now let's consider indirect effect. Now, indirect effect, cases to consider in this regard, von Colson, Marleisen, this is one of the ways that you consider, is this trying to bring directives via the back door? Well, when you look at indirect effect provides that if there is mal or bad implementation of a directive, then a court may seek, as far as it is possible, a national court may try to, as far as it is possible, construe that bad law along the lines of a directive. So let's say, using my example that I gave you with the nutology, let's say it came through as a directive and the UK has implemented. Now let's say the directive said that any product containing nuts must carry a written warning. Let's say the UK's implementation said any product containing nuts must say in bold letters, this product contains nuts. Remember, the directive said must carry a written warning. Now let's assume that I can't read, for example, so I buy the product. There may be an argument to say that the directive had been badly implemented by the UK setting out explicitly what must be said on packages, because I could arguably say that pictures should have been used. But the point about indirect effect is that the court must be able to construe it along the lines of the directive. They can't go out of their way to try and make it fit. It must be that so far as possible, they are able to construe it. So the point, of course, is that when you look at indirect effect, it does by and large allow some degree of coming in via the back door, but it is not so wide that a coach and horses can be ridden through it. It really is that the statute that has been implemented must be such that it allows for construction by the court. Now, we are going to take a short break. When we return, we will do a recap, and we will, of course, also look at what the Lisbon Treaty has in fact brought about and see how and where the EU is going immediately after this short break.